You're in-house counsel at a large consumer products company, and you receive a letter, maybe from a company you've never heard of before, notifying you of a patent that may be of interest to your company. The letter invites you to initiate licensing discussions about these patents. So what are the things that you look for immediately in this letter? Who's sending the letter? What public information can you find on this company? Have they initiated litigation in the past? Does the letter identify a specific patent or patents, or does it just tell you that this company has a portfolio you may be interested in? Does the letter identify a specific product that is supposedly infringing one of their patents? And is that product something that's unique to your company, or is this some third party's product that you're using off the shelf? All of these things are going to inform your next question, which is, what do I do with this letter? Now, you need to plan your next steps keeping two separate goals in mind. First, evaluating the risk to your company. Now, sometimes you may see these letters and, for example, there's no specific patent or product identified. In that case, you may not want to respond to the letter. That's because there are multiple types of licensing entities out there. Some will identify specific products from specific companies that they believe are infringing and will reach out to those companies. Others will blanket an entire industry and wait to see who responds, and you do not want to be the first person to respond in that case. So for the latter group, rather than taking some action that could bring the focus onto them, it may be the right strategy to avoid making any response. You also want to consider, is this your product or is this a supplier's? Many times you'll have in your contracts rights to indemnification specifically for patent rights and IP rights. You'll want to investigate those immediately and reach out to that supplier, not just because to do some investigation to determine whether or not the products actually meet the claims in these patents, but also because many of these indemnification obligations require you to reach out promptly. And second, how the response you make at this early stage could be seen years down the road in litigation, and what impact that could have on allegations that your company's infringement of those patents was willful. So I'm going to talk about the second goal, how best to respond to the letter. First, I'll review the current state of the law of willful infringement and the advice of counsel defense to it. Next, I'll discuss strategies for when to act, what to do, how to respond to these letters, and how to conduct your internal and external investigations. And finally, I'll describe how this investigation could eventually become part of a future lawsuit involving this patent. What types of privileged communications and work product could become subject to discovery if you rely on your investigation to defend against allegations of willful infringement? And what steps can you take to minimize that risk? Let's start with the state of the law. Now, willful infringement is embodied in 35 U.S.C. Section 284, a provision of the U.S. Patent Act. But that statute only states that if a defendant in a patent infringement lawsuit is found to infringe a valid patent, the court may increase the damages up to 3 times the amount found. That's all the guidance that the statute gives us. However, there is a large body of case law stating that courts generally should not enhance damages under Section 284 unless the infringer is found to have engaged in willful infringement. That does not mean that the courts must enhance the damages if there is willful infringement. Instead, enhanced damages are generally reserved for egregious cases of culpable behavior. Both the law of willful infringement and the scope of that waiver of privilege that we will discuss today are governed by federal circuit law, not by state law or by local circuit courts of appeal. That's because willful infringement is specifically provided for in a federal statute. And because that statute, Section 284, is rather undetailed, the law of willful infringement is currently in flux. It's really based on judicial doctrines, and there have been multiple sea changes on the law of willful infringement just in the past 20 years or so. Currently, the touchstone for willful infringement is a case from the Supreme Court in 2016 called Halo Electronics versus Pulse Electronics. In Halo, the Supreme Court fundamentally changed the law governing how courts consider allegations of willful patent infringement. It removed one of the two hurdles that a plaintiff had to prove willful infringement by removing the question of whether the infringer's conduct was objectively reckless. Instead, it only considered a subjective test that takes all of the circumstances into account. In other words, the focus is on the subjective mindset and actions of you and others at your company when you learned about the patents, not on whether you were ultimately able to present an objectively strong defense at trial. Or, from the perspective of a juror, to prove willful infringement of a claim, the patent holder must persuade you that it is more likely than not that the alleged infringer intentionally ignored or recklessly disregarded that claim. That's the instruction from the model patent jury instructions of the Northern District of California. And that's how a jury is going to be considering your actions years down the road in litigation. So as in-house counsel, this HALO ruling means that you must make difficult decisions about how to address allegations of willful infringement. And you must make them fairly quickly. The strongest defense against an allegation of willful infringement is to obtain an opinion of counsel in a timely manner after you receive this letter. Now, I say the strongest. It's not required that an alleged infringer obtain an opinion of counsel. In fact, unlike the very vague statute governing willful infringement, we have a very specific statute about opinions of counsel. That's 35 U.S.C. Section 298, which states, "The failure of an infringer to obtain the advice of counsel with respect to any allegedly infringed patent, or the failure of the infringer to present such advice to the court or jury, may not be used to prove that the accused infringer willfully infringed the patent, or that the infringer intended to induce infringement of the patent." Now that said, given that the HALO case focused solely on the mindset of the alleged infringer, these advice of counsel opinions have become much more common than they were just a few years ago. This can be advice of counsel from an in-house counsel or from an outside counsel, but it needs to meet three requirements. Number one, it must be competent. Number two, it must be thorough. And number three, it needs to be objective. Or, again, from the perspective of what a juror is going to be asked to consider years down the road, whether the alleged infringer relied on a legal opinion that was well-supported and believable. Now, well-supported and believable, that really goes to competent and thorough. But what about objective? How do you make advice of counsel objective? This strongly weighs in favor of having an outside counsel prepare an opinion rather than having in-house do it. That also strengthens your argument that your company reasonably relied on this advice of counsel. Defending against a claim of willful infringement by relying on advice of counsel also comes with a trade-off. You waive your claim of privilege not just to that specific advice of counsel, but also to all attorney-client communications that are part of the same subject matter as that advice of counsel. This includes any document or opinion that embodies or discusses a communication to or from your company concerning whether that patent is valid, enforceable, and infringed by your company. That precedent was established by the Court of Appeals for the Federal Circuit back in 2006 in a case called N. Ray EchoStar. This area of law has frankly been quiet for the last decade or so because between 2007, when a Federal Circuit case called N. Ray Seagate set the objectively reckless bar for willful infringement, and 2016, when the Supreme Court rejected that standard in the HALO decision, companies were much less likely to obtain advice of counsel opinions before litigation. Instead, they could rely on the objective reasonableness of their position after litigation started. These days, we're seeing this law begin to develop again, as companies accused of patent infringement consider how they can demonstrate that their subjective mindset was not reckless. So for now, let's talk about specific strategies for this scenario when you receive this letter. When to act, what to do, and how to conduct your investigation, knowing that years from now, there could be a jury looking back at what you did during this time. So you've received a letter identifying a specific patent and a product that infringes that patent. When do you need to take action? The question of what you did begins from this point. This pre-litigation period is where the willful infringement question is almost always going to focus. If you eventually get to trial, what you'll need to do is to show that you took action immediately. So who at your company should be tasked with handling this investigation and analysis? Preferably, you can designate a responsible in-house counsel who will not be involved in managing any subsequent litigation to lead this effort in your investigation. Why is that? Because that person might become a fact witness at a later trial. That in-house counsel should strongly consider retaining an outside patent attorney to do the analysis. This will make the analysis more objective and your reliance on it more reasonable. But this outside counsel should not be the attorney or firm you're going to go to for your litigation counsel down the road. The Federal Circuit's case law on waiver of privilege does not apply to trial counsel so long as that trial counsel is separate from your opinion counsel. Now, assuming you are using an outside counsel, get them involved early so that they can ask you what they need. And what do you need to do to protect your company? The first question is likely, are you going to respond to this letter, or are you going to keep your investigation internal? There are some benefits to not responding to a letter even after you do your investigation. That's because sometimes patentees might reach out to hundreds of companies at the same time and see who responds first. That said, assuming this is a letter identifying specific products from your company that are alleged to infringe a specific patent, you most likely will want to respond in some way. You can do so quickly at the outset, send a short letter in response, thanking them for their letter. You can take advantage of the response to put the onus back on them, asking them for more information to inform your investigation. For example, if the letter did not include claim charts showing an element-by-element comparison of a claim to one of your products, ask them for that. Otherwise, you can simply respond that you are investigating these allegations and that you will be in touch. Remember, all of this should be in writing. Assume these communications will be trial exhibits one day, and you will need to show that you acted responsibly. Another question you want to ask at the outset is whether the accused technology is some third party's product, such as a chipset in one of your products or a piece of software that you're running in your company. If so, consider reaching out to that supplier and request a written representation that their product is non-infringing or that the patents are invalid. Once again, all of this should be in writing. Assume that the communications will also be trial exhibits one day. Also, when you're having these communications with these third-party companies, consider stating that your company lacks insight into whether a particular feature practices a claim. Now, not only does this show that you're doing a diligent investigation, it also shows that you could not have been knowingly or intentionally infringing the patent. This is also the right time to start investigating possible indemnification obligations that supplier might owe to you or your company. But assuming your company is going to direct the investigation, you have to decide which grounds to look into. The easiest and the cheapest is usually non-infringement. That's because you can focus on one element of the claims that is not met. Invalidity searches can be expensive, particularly when you're dealing with a large number of these letters. That said, consider whether your company might have its own products that predate these patents. If so, it's a great way to scare off a lawsuit. Now, in either case, your goal is to obtain a competent opinion of counsel that years down the line, you can show the jury that you reasonably relied upon. You, or preferably your retained outside opinion counsel, will want to review the patent's file history and include that in any written analysis. You'll want to consider issues of claim construction, how the claims are going to be interpreted. This is another area where it's particularly helpful to have a patent attorney reviewing the patents. Interestingly, most local rules, including the local rules in the Northern District of California and the Southern District of New York, don't require a defendant in a lawsuit to disclose whether it is relying on an advice of counsel until after the court issues its claim construction order. So you have the added benefit of waiting until you know whether the court agreed with your patent attorney's interpretation of the claims before deciding whether to rely on the advice of counsel. Now, you also want to have your patent attorney ask you for the information he needs from your company. It may be helpful to have that attorney speak to an engineer with technical knowledge on the subject, but keep in mind that any privilege over that discussion could be waived if you end up relying on this opinion letter in a litigation. That means the engineer could be deposed. Any notes the attorney keeps from the call are also potentially discoverable. So do not create summaries of information specifically for this analysis. For example, don't have your engineers write an email summarizing how the source code works or what the technical specifications say. Instead, find the relevant documents as they're maintained in the ordinary course of business, then have your engineer speak with your attorney. Okay, so you've retained outside counsel and they have done their investigation. What is the final result? You typically want a written opinion of counsel stating the grounds for why your company does not infringe any valid and enforceable claims of the patent. You do not want to see the drafts. Those drafts are discoverable, and any changes you ask for are discoverable. If you want to get an answer before receiving the formal letter, it's better to call the outside attorney, have him explain to you why your company does not infringe any valid claim. Have your attorney reference that conversation in the advice of counsel letter. That way you can point back to it later and say you had a good faith belief as of the date you had that conversation. So what do you do with this letter now that you have it? You have no obligation to tell the patent holder that you believe you don't infringe. That said, keep in mind we are preparing a record of exhibits that are eventually going to be used as evidence in some future trial. A common response is simply to state, we have investigated the patents in your letter and have determined that our product does not infringe any valid claim of your patents. For a patentee that's casting a wide net, this might make you a less attractive defendant in a case because the phrase, product does not infringe any valid claim is a signal to them that you've obtained an opinion of counsel and are less likely to take a license. But a more focused patentee will either ask the reasons why or decide it is time to commence a lawsuit. So there's another opportunity, which is to convey why your company believes your products do not infringe in response to the patent holder letter. This is extremely effective evidence of good faith belief of non-infringement when you get down the road to trial. It can also postpone a plaintiff filing a lawsuit, but it gives away the advantage of waiting until after claim construction in the litigation to decide whether or not to disclose the grounds contained in your advice of counsel letter. Now I want to fast forward to the trial phase. The patentee is alleging willful infringement of a patent, saying that you had this letter before the filing of the lawsuit. You know you have your advice of counsel defense in your pocket, and you're deciding whether to rely on it. What should you consider? First, as I mentioned earlier, both the Northern District of California, the Southern District of New York have local patent rules that do not require you to disclose whether you are relying on an advice of counsel defense until 30 days after claim construction. This means that you can see how the court interpreted the claims and decide if either, one, you received such a good claim construction that there's no reason to even disclose your opinions of counsel, or two, that your opinion of counsel was so far off that frankly you're concerned it might not look competent. Now, usually it is somewhere in the middle of those two. So what is the real downside of disclosing these opinions of counsel that you worked so hard to obtain years ago? As I mentioned before, reliance on advice of counsel opinions waives privilege as to all communications the company had that relate to the same subject matter. This applies to communications that in-house counsel had with other employees of the company and to communications that outside counsel had with those employees and also with the in-house counsel. The one exception is communications with trial counsel. Those communications are not waived, and that's why you keep your trial counsel separate from your opinion counsel. In addition to communications with attorneys, there's a waiver of work product protections when a company relies on an advice of counsel. And it's helpful to think of this work product in three separate categories. The first is attorney work product that the attorney sends to you or your company. This could be the formal advice of counsel opinions themselves, or summaries or drafts of those opinions that relate to the same subject matter. Once you rely on the advice of counsel opinions, you waive privilege as to these documents. The second category is attorney work product that discusses a communication the attorney had with the client, such as a discussion that the opinion counsel had with the engineer. This is discoverable even if the summary itself is never sent back to the client. There's likely to be a lot of information in there that remains privileged, and this involves a very careful redaction of information that's not specific to those communications. Now, the third category is attorney work product that the attorney prepared in doing his analysis, but did not actually send to the client. For example, summaries of legal documents, legal research, or notes regarding potential non-infringement or invalidity grounds. The privilege protections for this attorney work product is not waived because the attorney never conveyed that information to the client. Again, remember, for willful infringement, we're focusing solely on the reasonable reliance of the alleged infringer, your company. Assuming the patentee down the road in litigation is going to go after all of these discoverable communications and work product, what steps can you take at the outset to protect yourself? Number one, again, do not use your go-to litigation firm as your opinion counsel. Privilege for communications with trial counsel are not waived, and you want to keep those two separate. Number two, do not generate internal memoranda beyond the opinion letters themselves. For example, summaries of how the accused technology works or lists of questions sent to the attorney. These are all going to be discoverable, and this includes email. Instead, as we've discussed, put your opinion counsel on the phone with a knowledgeable employee who can speak to the technology and have that employee provide the documents that he uses in his work every day. Number three, do not ask for drafts of the opinions of counsel. Any drafts that are sent to you are going to be discoverable, and the patentee will be able to ask about any changes that are made. Number four, if you're dealing with multiple patents, keep the analysis for each patent separate and independent. Waiver is on a patent-by-patent basis. Addressing each patent separately will limit the amount of information that you're later required to produce. And finally, remember that the purpose is not just to show that you obtained advice of counsel, but also that you reasonably relied on it. The patentee will be able to ask you who you discuss the advice of counsel letters with at your company. Consider discussing them with someone with decision-making authority, such as the general counsel, to establish that your company, and not just you, reasonably relied on the advice of counsel. Now, armed with these strategies, the next time you receive a letter regarding a patent that may be of interest to you, you should be more than ready to respond.
I'm a Superior Court judge. In my state, that's a trial court judge. What I want to do in the next 30 minutes or so is give you the world as I see it now. For many years as a lawyer, I wondered what it might be like to see the world through the eyes of a judge, and I thought I had a good idea of that. Turns out I was wrong. I can't talk about real cases, as you know, so what I'll do is I'll use hypos or composites to give you a sense of the kinds of things I'm talking about. First of all, a little bit about my background. For 8 years, I was a civil litigator. I was blessed to be part of a law firm that taught me to be ethical, tough, fair, but that meant going to the mat on lots of issues, but always within the guidelines of fairness and ethics. I took that really seriously. It was a part of who I was, a part of who I saw myself as a lawyer. And I would have told you then, and I would have meant it, that it was very important to my identity as a lawyer. Some years later, I went in-house. I led a large legal team for about 25 years, and I tried very hard to instill those same values as the leader of that organization. Again, taking it very seriously. But now I see the world through fundamentally different eyes. As a judge, I see the world in my courtroom as the search for truth, the search for justice. That's a high calling. And it's not a place where people go to bicker, to be petty. It's a place where people go with respect. I know it sounds corny, but to me, it's a holy place. So yes, we have an adversary system. That means that at times, things may get a little testy. It means that there are going to be disagreements, but we can never lose sight of the fact that we're officers of the court. That's a really important thing. We talked about that a lot in law school. I'm not sure how often on a daily basis we kind of touch base with that idea again. So I guess what I'm saying is I didn't have all my friends call the governor to put me in a place that would aid people in subverting justice, in hiding evidence, in avoiding the truth. As I see it, lawyers are my partners. They are my partners in the search for truth. Lawyers are officers of the court, and their job is to be part of the justice system. As in-house lawyers, you need to understand that the kind of representation that you have reflects on you and your company in a major way. What I don't think I appreciated enough as an in-house lawyer, that I wish I'd appreciated more, is that you have a litigation brand. The way that you appear in court in one case, the way that you manage yourself, the way that you conduct yourself, has a major impact on the way you're seen, not only in that case, but in everything that comes before the court. First, some basics. Actually, let's go very basic. ABA Model Rule 1.1 imposes on lawyers a duty of competence. Now that may sound like a silly thing to be talking about in an MCLE, but it's really important if you see the world through a judge's eyes. What it means from my perspective is knowing the difference between a law review article and a discovery motion. Let me paint you a picture. My workload is crushing. 20 to 25 motions a day on motion day. That may mean hundreds of pages to read every single night. I really can't do that if I'm honest. So what I need to do is to be efficient and to try to figure out the portions of the vast mountain of materials before me that are going to be worth my time to read carefully. So what that means for you is you want to respect my time. You want to make it easy. First and foremost, if I'm not going to be able to read your 100 pages or even your 25 beautiful pages, why not give me the 10 that I'll actually have time to read? You have the ability to choose the pages that I'll read by giving me a quantity of material that I'm actually able to deal with. That is a very important thing to bear in mind because you don't want me to miss something important. One thing that I see in briefs all the time that I frankly never did as a lawyer, that I find very helpful, are visual aids, charts, summations, almost the sort of things you might do in a jury trial. Yes, you may need the text, but if you're applying the law to 25 different items of accounting, why not lay them out? Why not give me a chart that makes it easy to follow your legal and factual analysis? That will make it so much easier for me to read and will maximize the chance that I understand what it is you're trying to tell me. That's actually a good general rule. Make everything easy to follow. Don't just throw everything against the wall and see what sticks, as they say. Be very concise. Now think about it for a minute. As in-house lawyers, you have to communicate with busy executives clearly and precisely all the time. Let me have some of that. Let me have the quick, concise, to the point, understandable argument that I can digest and understand. A few real no-nos. Boilerplate in motions would be a classic example. Almost every summary judgment motion that I read has 5 pages about basic summary judgment law. The procedural rules, the context. I've never read a word of that. The danger is in having that kind of boilerplate that there may be something specific, something particular to the law in your case that is buried in those 5 pages that I'll miss because you've hidden it in a bunch of boilerplate nonsense. The same thing can be said about string cites, about unfocused legal analysis, about rambling, endless paragraphs. I never read that stuff. Don't put it in a brief. I have a favorite quote, which I've heard attributed to Lincoln, to Pascal, to lots of other people. Like many good quotes, nobody's sure exactly who wrote it, but the quote is, "I would have written you a shorter letter, but I didn't have the time." I think that really applies to briefs. Take the time to edit it, to make it sharp, to make it focused, because it will be persuasive and because it's respectful of my time. Shifting gears for a minute, let's talk about the other kinds of things that come up frequently. I think something I didn't understand at all as a lawyer is how difficult it is to manage a calendar. Every minute in my day is precious. If I set an evidentiary hearing or a trial, I want to maximize the use of that time. That means that I can't really care about every single aspect of your life or your practice. So if you want me to care about your other cases, about your workload, about your vacation and personal time, pick one, because that's really about all the bandwidth I have to try to accommodate your scheduling. And don't play games on the scheduling. I can smell a ploy a mile away. It's something I deal with every day, and it fundamentally undermines your brand. Another thing that's very interesting to me to see from a different perspective is I always wondered why I had to wait around all day, or why everything about being in court was so inconvenient. I really wish that I could convey to you how busy my day is and how difficult it is to stay on top of everything. So please, don't annoy me by acting special. Don't ask for priority every time you come in. Don't project to me that you think that you're more important than everybody else is, and by implication, more important than the court. Those are the kinds of things that I notice. Again, they detract from your litigation brand. The most extreme example of this kind of faux pas is the ex parte. People bring ex partes all the time on all sorts of petty stuff. The analogy that I would ask you to think about as in-house lawyers is whether you would run into your boss's office to interrupt him or her in the middle of the workday. Because what you're doing when you come in ex parte is you're asking me to set aside all the work that I had planned for that day and put your work at the top of the list. You're burning capital, so make sure that it's worth it. Because as a new judge, I was really worried about people waiting in the courtroom and very focused on not wasting their time, I developed a practice of letting people know who had come in ex parte first thing in the morning that I would get to their matter as soon as I was able to, but given my morning calendar, there would be no way that would be before noon. I did that as a courtesy to them so that they wouldn't be waiting around wondering what was going on. Guess what I learned as a result of doing that? A solid 90% of the time, they would go out in the hallway rather than wait around all morning. They would figure it out. So why did they come in ex parte to begin with? Think about it. Very often in scheduling matters and the other kinds of matters that come in on an ex parte basis, There are 15 variables. I don't have time to sort all that out. Yes, it's a puzzle that you give me an hour and I'll figure it out, but I don't have an hour. So why don't you figure that out before you come in? Again, it's all about not burning capital with the court, because these are the kinds of things that make an impression on a judge. This is a good time to talk about ABA Model Rule 1.3, which imposes on all lawyers the duty to act with reasonable diligence and promptness. Believe it or not, that's the rule that is always cited as imposing on lawyers the duty to act zealously. In fact, that requirement, that language was taken out some years ago and replaced by the reasonable diligence language, recognizing a lawyer's role as an officer of the court. So that means a couple of important things in my courtroom. First of all, can you please figure out if you're going to settle a few days before I've spent countless hours preparing for your matter? Maybe you can find some way to pretend like you're on the courthouse steps a few days before. Courts are starting to help more and more with this by requiring meet and confer processes before an action or matter can actually be brought before the court. That's why. Lots of motions are resolved this way, but lots more come to the court without any meaningful effort to resolve them. So again, I'm asking you, why not earlier? And remember, if you waste my time by settling an important motion or even a trial on the courthouse door, next time I'll remember, and I won't even bother preparing until you show up ready to go. I have to do that to manage my time. If that happens, you can wait. So please bear in mind the importance of getting ahead of these kinds of issues. And yes, as a lawyer, I can imagine a lot of reasons why it could happen that something doesn't settle until the last minute. A lot of those reasons have even come out of my own mouth. Please know that from a judge's perspective, all of those reasons, whether it's not wanting to look weak, not having the time, not having the focus, are just different ways of saying your time is more important than mine. Please don't do that. The kinds of examples of this that can really get you in trouble are lengthy motions to dismiss and ridiculous discovery motions. There, the meat of what you're trying to say can get lost, and I'll talk more about that in a bit. So let's talk about what it's like to see ourselves as others see us in my world. Now that I'm on the other side, now that I'm on the bench, this seems really obvious to me, but I guess I missed it when I was a lawyer in the heat of battle. You have a huge opportunity to build goodwill with the court by being forthright, by being clear, by stating your case, by knowing your case. And the good news is you'll actually be a more effective advocate by doing this. So what do I mean by this? Let's talk about one of the most common issues that I referred to a moment ago, the discovery motion. What do you think it looks like to me when you come in on a discovery motion and you have objected to every single request? What do you suppose it looks like to me if all of the objections look the same? Do you think it creates the impression that you're being forthright, that you're being honest? Of course not. It looks like you're trying to hide something. And that creates the impression in the court that you have something to hide. Another very common manifestation of this is ignoring mandatory statutory language in responding to discovery requests. Typically, a discovery statute or rule of court lays out the kind of response that you have to give. And yet all the time I look at discovery responses where I cannot tell if the individual has something, if they've produced it, if they're trying to hide something, where they are in terms of their actually complying with their discovery obligations. How does that feel like a holy mission to discover the truth? Remember, it's called discovery. That's when you show the other side your case, presumably because you think you have a good case. So what does a discovery motion look like in a small town where you have to see the same judge over and over again? Yes, maybe you start off with the same endless list of 50 requests and 50 objections, but then you meet and confer, you work 49 of them out, and you go before the judge with great trepidation to ask him or ask her to call a ball or a strike. That's what a discovery motion should be like in any court, because when you're arguing about why you haven't complied with your discovery requests, you're losing. You're adversely affecting your litigation brand. Here's a really tough one. I used to say when I was an in-house lawyer that if I ever got fired, it would be because I let the CEO get deposed. So I understand completely how important this is. I also understand as a judge that it's one of those places where companies very often look ridiculous. One of the things is I'm amazed at how many different CEOs a lot of companies that appear in my court have. You kind of need to pick one, because otherwise when you have the motion that you really need to win, your credibility is seriously undermined. More importantly, I would say, if you come before the court trying to protect the CEO from a deposition, it's pretty obvious if what's going on has a sound foundation or not. There's clear law, so follow it. I strongly recommend that you have a difficult conversation with your CEO as appropriate, that you negotiate limited terms of a deposition, and that you try to avoid bringing it before the court. That does a couple of things. First of all, you don't have to burn any of your capital. And second, if you do end up in court, you look so much more reasonable. If you're going to bring a frivolous motion to try to exclude the deposition of your CEO, then you also need to know to disclose to the CEO that you're actually doing something adverse to the corporation, because after all, the corporation is your client. What are you doing? You're ruining your credibility with the court. Another place I see parties fall into this trap all of the time that is absolutely destructive to credibility is by bringing serial motions to quash discovery. And what do I mean by that? There will be a third party that's clearly aligned with the party. The party will then bring before the court the desire to not have that discovery, lose. Then the third party will come before the court, make that motion again, contending that they weren't really involved in the first hearing before the court. That's silly. It makes you look bad. Don't do it. And again, apropos of what I was saying earlier, remember Model Rule 1.13a. You represent the organization, not any individual. You don't want to make that organization look bad. So, in terms of your litigation brand, where do you want to be? Believe it or not, I occasionally see folks who voluntarily disclose in accordance with the rules, sometimes even beyond the rules. What they're doing in taking those steps is they're showing me they understand their role as officer of the court, they know their case, and they believe their case to be strong. They lay it out, and they live by it. That creates an incredibly powerful, favorable impression. In my world, where a big part of my day, every day, is taken up by listening to people squabble over nonsense in discovery motions, the person who walks in and says, "This is my case, I know it, I've shown it to the other side, here's the case in a nutshell, the documentary evidence to back it up," that makes an incredibly powerful impression. When a critical discovery issue comes up, who has a head start? Who do you think I look to and give the benefit of the doubt? This is incredibly valuable to your litigation brand. I want to talk about the other things that come up in the course of a trial. We've been focusing up to this point on things that tend to happen more during the discovery process, but they're different versions of the same thing. I see people shamelessly lead their own witnesses. I see them jumping up and down, making silly, repetitive speaking objections, even when I call them on it. And whether or not the objections are overruled is actually the least of your problems, because the impression that you're creating is that you have something to hide. The impression that you're creating is that there is a truth out there and you don't want the court to see it. That kind of action is directly contrary to ABA Rule 3.4 that says that a lawyer shall not obstruct another party's access to evidence or knowingly disobey any discovery obligations. It's really important to keep that in mind, both during the discovery process and at trial. It's fundamental to your litigation brand. Now I want to talk about some of the really critical stuff. And this has made a huge impression on me as I've been a judge. My first assignment was to an area of law that I knew very little about, so I was on a crash course to try to learn it. Within a very short period of time, I identified the lawyers and the individuals, the companies and their counsel, who would constantly, reliably come to me with the absolute black letter law. If they were arguing for an extension of that law, they would tell me that. If they were arguing by analogy, they would tell me that. If they had a case that was actually binding authority, they would tell me that. If they were making a novel legal argument, they would even tell me that. I immediately noticed the lawyers who are always 100% straight with me. And those lawyers reflect well on their clients. By the same token, you don't want to be one of the ones who has been shown to not be a reliable reporter of the law. And there are plenty of them out there. Okay, so in looking at these issues, remember Model Rule 3.3 that says that a lawyer shall not knowingly make a false statement of fact or law to a tribunal, that a lawyer must disclose controlling legal authority in that jurisdiction. But don't think that you've done enough by just doing that. What you need to do is be the person who is always 100% reliable. You want to be the company that is always accurately stating the law and the facts. By the way, one side note to this, there's a huge trap for the unwary in that model rule regarding ex partes, and I see this violated on a daily basis. When you come before the court on an ex parte basis, you actually have an obligation not only to state your own facts and law, but the other side's facts and law. That's absolutely clear in the model rules. You have to, in effect, be an advocate for both sides. It creates a terrible impression when you come in ex parte, you don't tell the whole story, and obviously you're very quickly going to get called on it. very bad for your litigation brand. Another thing that I see all the time, as a company, you need to be consistent in your legal positions. Having your own briefs quoted against you is not good, and it's something that I see all the time. So when you're a plaintiff, for example, you argue for a very expansive view of consequential damages. When you're a defendant, you take the opposite position. This is multi-dimensional chess. You have to think ahead. It is the game you signed up for, and if you're going to play it well, you have to take positions that are consistent. I also see this all the time in discovery motions, where in one motion, perhaps even a motion that's pending on the same day as another motion, they'll take very different views about the proper scope of discovery. I even see it on the elements of claims. It creates a terrible impression and significantly undermines your credibility with the court. So in trying to bring all this together, I want to talk for a moment about Rule 2.1. That's a rule that I used to read and wonder what in the world it was doing in the model rules. What it says is that a lawyer can advise not just on legal issues, but on moral, ethical, political issues. It turns out that it's not just a throwaway rule at all. It's critical. It goes to the heart of your brand. What you want to do is show yourself to be that company that is proud of its legal positions, that is proud of the way it conducts itself, that conducts itself with honor, and that values all of the aspects of corporate citizenship. That is the corporate brand that you want. That's the litigation brand that you want. And Rule 2.1 gives lawyers the ability to bring that home.